Hello, this is my legal rant of the day. My name is Maurice Ross, and I want to spend a lot of time on these legal rants reporting about circuit court decisions. Most of the attention in the media is paid to decisions of the Supreme Court of the United States, but where the action is often in the circuit courts of appeals, the federal circuits, which are one stop below the Supreme Court. You have district courts, which are the trial courts, and then you have the intermediate courts, which are the courts of appeals, and then you have the Supreme Court. And the decisions that matter the most for most people are handed down in the circuit courts. And on August 22nd, the Second Circuit Court of Appeals, in a very, very important case involving the Second Amendment, the case is entitled the National Association for Gun Rights against the Attorney General Ned Lamont of the state of Connecticut. And what happened is, after Sandy Hook, terrible shooting in the Sandy Hook Elementary School, the Connecticut legislature passed laws that banned the acquisition and possession of assault weapons and large capacity magazines. And the gun rights organizations challenged those laws under the Second Amendment. The Second Circuit, in a very, very important ruling, held that the Second Amendment rights are not unlimited. Using the tools of history and tradition and the analysis of the Supreme Court in the Heller case and in the Bruin case, the Second Circuit concluded that the plaintiffs' gun organizations had not shown a likelihood of success on the merits of their claim that the Connecticut laws restricting the use of high-powered guns is unconstitutional. The court held that, in fact, the history of regulation in this country showed that there was a tradition of imposing strict limitations on the possession and use of dangerous weapons such as AR-47s and automatic rifles and machine guns. And the court upheld the Connecticut law. This is extremely important. I have been saying all along that the court in Heller, when it acknowledged the existence of Second Amendment rights, made clear that it was not intending to drastically limit the ability of the states to enact gun control legislation to keep out of the hands of people unusually dangerous weapons such as AK-47s. And now the Second Circuit, which is one of the most important and respected courts in the United States, has upheld laws banning possession of these dangerous weapons. And while the Second Amendment MAGA people may scream about this decision, it is correct. It is clear from Supreme Court precedent that the states have the power to enact very strict limitations on the possession of dangerous weapons. This case is good news indeed. And this is an example of how the circuit court decisions may shed light on very important and controversial issues and are often where the action is. And this Second Circuit opinion, which has not been reported in the mainstream media, deserves widespread attention. It's good news indeed. The Second Amendment does not prohibit states from enacting laws to prohibit the possession and use of AK-47s and other automatic weapons.